come in and was going to talk to the students and people around the neighborhood.
Do you know who the guest speaker was?
I do.
And who was that?
It was Charlie Kirk.
Did you see Mr. Kirk that day?
I did.
When did you first see him?
When he arrived on campus, just behind the west side of the Hall of Flags, I saw him pull up.
And can someone access the courtyard through that area?
Yes, they can.
How so?
Where he pulled up underneath the Hall of Flags is a opening to where you could drive a car underneath. So there's access right there. You could walk or drive underneath the Hall of Flags.
And you saw him arrive?
Yes.
Okay. Can you describe what you were seeing? What did you observe?
On that day, I observed Charlie going back, doing some meet and greet with some people, getting some photos taken. He then came underneath the Hall of Flags and went to his tent, and he was there answering questions and talking to individuals that would ask him questions.
The tent you're referring to, is that the tent that we see when it was set up in the courtyard?
Yeah, that white square tent.
The white top?
Yes, he was under that.
Fast forward to about 12:20 or so a little bit after noon, the noon hour. What happened? What did you see and what did you hear?
I heard an individual talking to Charlie, and I happened to kind of glance over the edge of the railing about that time. I could see the right side of Charlie's shoulder, so not his whole body, because he was underneath the tent, so I could only see probably the right side of his body. He was answering a question, kid asking him a question, and then I heard a shot fired.
Do you know what time that was?
Yes.
What time was that?
12:23.
What did you see?
At that moment, I saw him lean to the left. So
When you say him, you see
Charlie.
Charlie?
So I saw him go to the left because I could no longer see the right side of his body. So he went further underneath the tent to the north side of the tent, so left.
Okay. Can you describe the reaction of others that were there?
Yeah, so then everybody started getting up and starting to run in more of a chaos kind of situation.
Before you continue, can you describe a little bit? So you mentioned Mr. Kirk was answering questions, talking to individuals.
Yes.
Were there others present?
Yes.
Any idea about approximately how many? How would you describe it in your terms?
In my terms, I'd say when I was up there looking down, I'd say there were several thousand people, because you had it on the grass that was jam-packed, in the amphitheater sitting on the grass. You had people standing on the back up along the cement. You had people that were on the second level, the Sorensen, and over by the Woodbury building. There's another level there where a lot of people were standing and watching. So it was pretty packed. Okay. Several thousand people.
You mentioned you heard something. What did you hear again?
I heard a gunshot.
Okay. And can you describe you described Mr. Kirk's reaction? Was that simultaneous to hearing the gunshot?
Yes, it was.
When he fell to the left?
Yes.
Did you see the reaction from the crowd?
Yes.
What was that?
Everybody kind of got up. They all said, a lot of people were screaming, standing up, and starting to run in all different directions away from the center of the tent.
Okay. You're a police officer helping to secure the area, correct?
Yes.
What did you do?
At that moment, I recognized it as gunfire. I left my post, which was right there on the south end of the Hall of Flags. I proceeded to right where the Fugle and the Hall of Flags meet. There's some outside stairs that I was starting to run down. As I was trying to get down to the bottom of the stairs, people were running up, people were laying down on the steps. I'm trying to jump over people to get to the bottom of the stairs so I can help stop an individual that's probably shooting.
What happened next?
By the time I got to the bottom of the stairs, I was informed on the radio that we had a shooter in custody. So I thought at that moment, I was like, oh, that was kind of fast. Obviously, it was close range probably, because we had an individual in custody. Another officer came on and said we had an individual in custody. So I decided to, since the threat is gone, now I can assess for anybody that's injured and start looking for any medical needs that's needed at that moment. I started canvassing the area. As I canvassed the area, I was looking for anybody that was injured. I saw a kid on the ground that was on about the second or third tier in the grass next to a wheelchair, and he was almost convulsing. I thought he'd maybe been shot. Talked to the dad as I was running over there. He said that he was just having a seizure, that he was fine, he was not injured. So then at that moment, I observed that there was no other injuries that I could see at that moment.
Okay. Was your attention drawn to anything? And I would ask for the witness to come down to explain the exhibit.
All right, officer, if you'd like to step down, use the microphone, and as previously noted, describe, when you're describing something on the image, where it is located on the image for the benefit of our recording.
So, officer, will you describe for the court what it is that you're looking at?
So what I'm looking at is I'm on top of the Losi building, which is where the gravel is on towards the bottom center. I'm looking west towards the tent, which is in the upper center, that you got a white tent. You can see the grass down there in the amphitheater. You got the hall of flags that's more towards the top center, and behind that you've got I-15. But what I'm looking at is in the disturbance of the gravel is what I saw that day.
Okay, and what can you describe for the record that disturbance?
To me, when I got up there and I could see this disturbance of gravel, to me it looks like a sniper pad, a person that has been laying in a prone position, and you've got markings of elbows, knees, and feet to where somebody was in the line of sight of where Charlie's tent was.
Thank you. And if we could, again, take the, if we could publish State's Exhibit number 2. You recognize that, right, officer?
Yes, I do.
Where on the Losi rooftop did you observe this disturbance in the gravel?
If you go to the
Can you
center of
point
the
to that?
picture, if you go to the center of the picture in the darker gray part of it, on the left side, so the south side of the Losi building, it would be right in the line of sight of the Charlie Kirk tent that's straight in front of it,
Okay,
or the southwest side of the roof.
thank you. You can take your seat. And finally, I would direct the witness's attention to State's Exhibit number 5 on the monitor. Let me know when that's there.
It is.
It is
Yes.
there. Do you recognize that exhibit?
I do.
And what is that?
This is going to be a picture of the side profile of that last photo we looked at with some red or orange markers and a number 2 with also a tape that's there on top of the Losi building.
What was that tape that you said?
There's a measuring tape, it looks like.
Okay. Are you able to tell which direction the photographer was facing?
Yes,
And what direction is that?
it's facing south.
This is a nighttime photograph, correct?
Yes,
Do you know who took this picture?
I do.
And who took the picture?
It was Melissa Richards.
The same individual that you spoke about before?
Yes.
Did you ask her whether this is a fair and accurate depiction of what she observed
Yes.
that night?
Yes.
What did she say?
She said it was.
With respect to what you observed that day, apart from the evidence tag, the yellow tag, as well as the orange or red markers, is this a fair and accurate depiction of what you observed?
Yes.
What's different about what you observed as far as what's on the photograph, the previous exhibit, compared to this?
You can see more of the length of an individual. So you can see that there's 2 elbows, 2 knee areas, plus also towards the far right of the photo is also a marker where like somebody laid a gun down.
Okay.
It's like a prone position.
Your Honor, pursuant to Rule 1102 as well as other, officer, upon seeing this disturbance in the gravel, you've described what it looked like to you?
Yes.
Someone lying down in a prone position, correct?
Yes.
What did you do next?
So when I got to the top of the Losi building during that day, I noticed the screwdriver, kept going to the edge, found that prone position. At that moment, I realized, because it was direct line of sight, plus the disturbance in the gravel, where I could see somebody laid down in a prone position or a sniper position, and asked dispatch to get on the then I realized that we probably didn't have our shooter in custody. From that moment, I asked dispatch to get on the camera system and to see if anybody was on top of the Losi building during the time of the incident.
Were you advised of anything?
I was. Dispatch came back and advised me that there was a male individual on top of the roof that was there at the time of the shooting.
Did they describe what his movements were?
They did. They stated that he ran to the edge, dropped down, crawled, got in a prone position.
I'm going to stop you right there. Ran to the edge. What direction and what edge?
Running west and southwest of the Losi building. So ran towards the tent of where Charlie Kirk was, so they could get a line of sight. And then the individual stood up after the shooting and ran northeast on the top of the Losi building.
Okay. You mentioned that this individual on the video dropped off the edge. Did you get that?
I haven't mentioned that.
Oh, what happened? What else was described to you?
Then, well, at that moment, so I knew that there was possibly a shooter on the run.
Your Honor, can we just have a continuing objection to all of the hearsay that's being testified to here?
And Judge, my response to that was I'm not actually offering this for the truth of the matter asserted at this point, simply for the effect on the hearer. So I'm not offering what's been described in the video as substantive evidence.
All right. Ms. Nestor, with that clarification, any thoughts?
I'll just stand on the objection. I don't think, I mean, he's clearly offering it for the truth because he's asking him to describe the route of the individual, and it's based on what other people told him. So if he wants to circle back to it after he's put the video in, I mean, we could do that. But right now, I still think it's inappropriate hearsay, Your Honor.
All right. Anything further, Mr. Hernandez?
I'll submit it to the court.
All right, so as the magistrate, as this is not to a jury, it's to myself as a magistrate, I am not accepting that statement for the truth of the matter asserted, simply for what has been stated. So I'm specifically making that finding as I'm receiving this evidence, and I'm not accepting it for the truth of the matter asserted, only as represented by Mr. Grunander. And with that, the objection is overruled. Mr. Grunander, you may proceed.
Thank you, Judge. So you mentioned
We got to ask this now. Did you use AI to help you prepare your report?
I did not.
Okay, good. When you prepared your report, you referenced when you first heard the shot, don't you?
Yes.
And what is the time that you say that you heard the shot?
12:23.
Right. And when you wrote that report, you did not state in your report the direction you heard that shot come from, did you?
No, apparently not.
And take your time and look at the whole report and see if there's anywhere in there where you ever mentioned that it came from the east or to your right.
I don't see a direction.
Okay. And you also, I believe, in your report, you also don't state whether or not, you don't mention anything about thinking it came from the Losi building or anything like that, right?
Later on, when I recognized when I saw the empty holsters, I think I actually said that in there, where I see the empty holster, that I realized the line of sight.
Okay. So let's talk about that holster for a minute. So you heard the shot, and you only heard one shot, correct?
Yes.
And then you came down from the walkway above the tent, right?
Yes.
And you came down to really the grassy area that we've all been looking at, the courtyard.
Yes.
And there was kind of chaos, people running around.
Yep.
Yes. And while you were down there, you saw what you said was an empty holster.
Yeah, as I was clearing people out and making sure that the evidence was preserved, about towards the top, after a little bit, I saw an empty holster sitting there.
And when you say towards the top, can you be specific and tell us where you were?
So on the south side in the courtyard, there's some tiers of seating where the grass is different levels, and it was towards the top, maybe just right before the cement is where everybody's standing. So there's different levels. It's towards the top on the grass.
And when you saw the holster, can you describe to me what it looked like?
An empty concealed holster.
For what type of
For
weapon?
a pistol.
Okay. And did it have any markings on it?
I didn't even know, not that I noticed.
And what happened to that holster?
I have no idea.
Did you ever take custody of it?
Nope.
Did you ever tell anyone else to take custody of it?
No,
You just left it on the grass?
I did.
Was it ever fingerprinted to your knowledge?
I have no idea.
Okay.
Do you have a version of this video that does not have alterations, such as zooming or circling? My concern is that if the 1102 says what it says about the videos, these were the videos.
Right.
But then it was altered. And typically an exhibit which has been altered, and if it wasn't done by the person who supplied the 1102, that can become problematic. And so do you have a version of this exhibit that does not have the zooming in or the circling? Again, I don't know all the alterations that were made, but that seems to fall outside the 1102 because you don't have a person testifying 1102 saying, I made the alterations.
Right.
And so that's the concern of the state of what Ms. Nestor was talking about as it relates to the state's evidence. I have that concern about those alterations. I don't know when they were made, what they were made, how much was done to manipulate the video, and I say manipulate to, not saying it in a nefarious way, but I don't know what the scope of that is and how much it deviates from what was the original form.
Well, Judge, to answer your first question, do we have a version of this particular video that has not been altered? We don't, not right now, not today. I guess there's a couple of things I'd simply like to point out, Judge, and that is that we have two witnesses who have watched the raw footage. And Agent Hull here today on the stand and Mr. Olson in the form of his written statement, they have both said that this video, with the exception of these alterations, accurately depicts the video that was captured by UVU surveillance video. Judge, I will proffer that those changes made to the video were not done by either. I know who that person is. We could actually call that person as a witness if that would cure that. And we're prepared to do that if necessary. But Judge, I think that our burden is to simply authenticate, what this is. And it is a video that, with only a few exceptions, alterations, that really don't change the substance of the video or the content of the video, they're accurate. They depict what the cameras captured on September 10th and the 11th. And we have two people who have seen that raw footage and they've explained that's the only difference between what we have originally in the original videos and what you're seeing here today. And the additions, I will submit, Judge, were only added to make it easier to view.
All right. Anything further from the parties?
No, Your Honor.
All right, I'm going to go ahead and I'm sustaining the objection. Typically, when exhibits are admitted to the court, it is without alteration. If a party circles an exhibit, a photograph, that's not the original format, and I do not have the person who made the alteration, an 1102, to substantiate that. And what I have is the original video, and Mr. Olson saying, this is the video minus the alterations. And we have Agent Hull saying, this is the video and there are alterations, but I'm missing a link. And it may be minor, but in this type of case, I want to be thorough. And I want to make sure that what is minor is still important. And for those reasons, I'm going to sustain the objection and leave it to the parties on how you wish to handle the video in the future. I don't want to provide guidance either way.
Right.
But as it stands today, this exhibit, State's Exhibits 12.1 is not admitted.
Okay. Judge, could I have just one moment?
You may. We're
Well,
going to resume with Mr. Hall tomorrow morning.
Tomorrow morning, and let me explain and I was going to explain this, but let me explain why. Judge, our intent is to prepare an original version of the video that has been in dispute today, without the circles, without the blur, and without the zooming in. And our intent is to introduce that tomorrow as a different exhibit. And we just can't prepare that in the next hour or so. So we're going to need this evening to prepare that exhibit. And we'd like to return with that. Judge, what I would also suggest, well, let me get your take on that, Judge.
All right. Does the defense wish to be heard about ending for the day? We have about 19 minutes until 5 o'clock. What is the defense?
Your Honor, we're happy to accommodate the state on that.
All right. So for today, Agent Hall, you may fair trial or interests favoring closure. And the court recognizes the importance of the constitutional rights of Mr. Robinson being upheld and protected. At the same time, the court also recognizes the importance of transparency and a proper balance to ensure that the constitutional rights of all parties are upheld. As it relates to this exhibit, I believe it's 12.4.
12.4, yes.
Based off the representation of what is in that, the court differentiates this exhibit from the exhibits from yesterday, namely Exhibit 7, Exhibit 8, and Exhibit 9, as those are different in nature, and those go to issues relating to Utah Constitution Article 1, Section 28, as it relates to the Declaration of the Rights of Crime Victims. And the court also recognizes Utah Rule of Evidence 1102, as that is the foundation that's being laid for the admission of this exhibit. Having taken in consideration all factors, the court rules that Exhibit 12.4 is admitted into evidence and shall be played in the courtroom and may be broadcast by the media. We can proceed.
Thank you, Judge. Just see happen.
The individual actually kind of rolls over the railing onto the roof of the Losi building.
All right. Go ahead, sir.
And again, in the top left corner, the individual is now seen running across the rooftop of the Losi building to what would be the southwest corner of the building, crouching down and then crawling to the corner of the building.
And this is at what time?
Around 12:23. I think the timestamp on the video is 12:22.
On the 10th.
On September 10th, yes,
So
2025.
we're clear, this is the roof of the Losi building.
Correct.
Can you still see that individual?
Yes, you can, laying prone.
You believe this to be Mr. Robinson?
I'm sorry?
You believe this to be Mr. Robinson?
I do, yes.
And how long is he out there on the edge of the building?
Just until the reported shot was fired at 12:23 and 28. The individual then stands up and then moves across the building to the north.
Is that what we're seeing happening right now?
It is, yes. They move behind the atrium area on the rooftop to the northeast corner where the white triangle is.
Do you see Mr. Robinson now?
I do, yes. He's just arriving at the corner of the building, almost the top center of the image.
What are we seeing now?
And Mr. Robinson lowering and jumping off of the roof of the Losi building onto the grass area, and then moving away towards Campus Drive. And he appears to be carrying some kind of an object in his hand at this time.
Question. Any question that the court asks is a question that counsel should take seriously. The legislature separates in the statute religion and political expression. The state selected the victim targeting enhancement based on political expression only. Now the state wants to I didn't bring Matthew in. The state is bringing Matthew in through Mr. Engelhardt. I didn't bring the Bible to this courtroom, the state brought it. And that concerns me greatly because the state is turning this into a question of whether Mr. Robinson's views, identity, life are anti-Christian. And that's a huge problem. And the state has created that problem. And this hearing is being broadcast to the entire jury pool. And that's what Mr. McBride just did, is he turned this case into whether Mr. Robinson's life is inconsistent with what Mr. Engelhardt calls Orthodox Christian views. I'm going to just stop right here because I think the court knows what the problem is.
Thank you. All right, anything further before the court makes it? All right, Mr. McBride, turning to the state.
Yes, Your Honor. Just by way of preview, we are going to call Jen Falmuina, Sergeant with the SBI, but how we're going to proceed is we're going to call her for a very limited purpose. We're going to pause her testimony. Defense is not going to cross at that time, and we're going to call an FBI DNA analyst out of order. It's a defense witness, but that's to accommodate that witness's schedule. Okay. State calls Sergeant Jen Falmuina.
Like to come forward? I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors at the top of that page, if you will.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 7 sub 1 and are 1.7 octillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs' DNA was obtained?
I'd like to reserve the right to cross-examine after the witness completes her testimony after the following.
Oh, would you mind grabbing the microphone? I just want to make sure what you say is on the record.
With the court's permission, I'd like to reserve the right to cross-examine on the area she testified about until she's completed her testimony.
Okay, okay, I see what you're saying. Any input, Mr. McBride?
Your Honor, that's what we expected to happen. We discussed this beforehand. We stipulate.
All right, that's fine. And so should I have the sergeant step down or?
Yes.
Okay. Sergeant, if you'd like to step down, you're still under oath, and so please don't discuss your testimony with anyone. And is she being asked to exit the courtroom, or what's the request of the parties?
Yes, to exit the courtroom at this time.
All right, Agent, if you wouldn't mind exiting the courtroom, and then we'll come get you when we're ready for you. All right? Thank you. All right, Mr. Burt, turning to you.
Your Honor, out of order, the defense would be calling Amanda Baker.
All right, Ms. Baker.
Okay. Under the topic absolute identification, is it the policy of the FBI when you're reporting out results that an examiner may not state or imply that a match provides an absolute identification of the individual from whom the biological material originated?
That is correct.
And you were following that policy in this case when you told the investigators that this was a possible match, correct?
That is correct, yes.
You never said it was an absolute identification of Mr. Robinson, did you?
Correct, no, I did not.
Now, the second guidance under that policy is an examiner shall not use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty in either reports or testimony unless required to do so by a judge or applicable law. You're not, in your report, did not use any language that suggested you were giving an opinion to a reasonable degree of scientific certainty,
That is correct, it was not.
okay? And then the next one, not that one more down. Not going to talk about race, ethnicity. That doesn't apply to this case, right? But 5.4 says, an examiner may not state or imply that forensic autosomal DNA examinations have a zero error rate or are infallible.
That is correct.
And you followed that policy in this case, correct?
Yes, I did.
You're not in your report stating to the court that your testing has a zero error rate, correct?
Correct.
You're not saying that the test is infallible.
I am not, no.
What is the source of error rates in DNA testing?
I'm
You can
sorry.
take that down.
Can you clarify your question?
Yeah. When it refers to don't state that there is a zero error rate, what in general are the sources of error in DNA, in the kind of DNA testing that you do?
Human error could be an error.
Anything else?
Not that I can think of off the top of my head. One of the big things is potential human error. I guess you could also associate the DNA testing itself and how items are collected or how those items are tested.
Now, to your knowledge, that policy statement that we just read in Exhibit 7, Baker 7, was based on a more general Department of Justice policy, correct?
Correct, yes.
And that policy is called the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examinations using probabilistic genotyping systems, correct?
That is correct, yes.
And could you display 8 for us, please, to the witness? Let me know when it's on. No, not on the big screen.
Okay, so not to go onto this main big
Correct,
screen.
this is
Thank
just
you.
for the witness. And you're familiar with that policy, correct?
Yes, I am.
Okay. And does it contain a statement that support for inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample?
I believe it does, yes.
And did you follow that procedure in this case?
Yes, I did.
All right. Does this same policy state at page 4, fourth down, one more. No, next one. An examiner, does a policy state, an examiner shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample?
That is correct, yes. It does state that.
And you followed that procedure in this case, did you not?
Yes, I did.
You're not implying that those numbers that a previous witness quoted and are stated in your report provides an absolute identification of Mr. Robinson or Mr. Twiggs?
No, I'm not.
Okay. Thank you. You can take that down. Let's verify that if we could. Take that down, the highlight. And repost 38, page 45. I'm sorry. Page 39, that is in evidence. There we go. Second page. Is this the likelihood ratio from your Twigs comparison?
Yes, it is.
Okay. Now, what was the likelihood ratio that you calculated based on this chart?
The likelihood ratio was 1.
1.
Yes.
So that doesn't rise to the level of even limited inclusion, correct?
Correct. It would fall under an uninformative.
Uninformative, and yet you concluded that despite this STR mix reading with a likelihood ratio of 1, that Mr. Twigs was a contributor to both item 7 and item 8, correct?
I did. So actually, I didn't utilize this calculation to determine that Mr. Twigs was a possible contributor or that I could use him as an assumed contributor. I visually looked at the DNA sample, and the DNA, unlike that major contributor, he also had those peaks. So that was one proposition or one hypothesis that I determined that he was an assumed contributor. There are multiple different ways. We don't have a threshold. I don't have to see 2, 4, 8 peaks to determine I think an individual is present. Given that the field submitted him as an elimination, I assumed he was a contributor. When I compared him to that data, I did see his DNA present. So when I calculated the statistic for Mr. Robinson, I used Mr. Twigs as an elimination.
Let me see if I understand that. The STR mix that you relied upon to include Mr. you relied on the STR mix to include Mr. Robinson as a possible contributor, correct?
Correct, yes.
But when you ran Mr. Twigs's sample through STR mix, the result you got was that he was not a contributor, correct? Or that it was of not even of limited value in including him.
Based on the STAR mix run, it was uninformative, but I did use my own knowledge and training to determine that I was going to utilize him as an assumed contributor.
Okay. Your own knowledge and training. Is there some standard?
Thank you. So item 7 sub 1 is the swabbing from the towel from the rifle. We have the number in a written form in the second paragraph beneath the heading, and then beneath that you have a table, correct?
That is correct, yes.
And the likelihood ratio gives the number, right? That's the likelihood ratio. And that's stated in sentence form in the paragraph preceding the table, correct?
Correct, yes.
The only language you can use to describe what that number means from the DOJ directive is very strong support for inclusion, correct?
Correct, yes.
And the sentence there that says the DNA results from item 7.1 are 1.7 octillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors. The reader can assign whatever value they want to that, correct?
What do you mean?
Meaning adjective to describe what that means.
Sure, yes.
The adjective you can use is very strong support.
For inclusion, yes.
Okay, for inclusion. All right, if we go to 8.1, Kimberly, if you can scroll down just to make that a little bit easier to view. Same question there. The results are from 8.1 are 30 quintillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors. The adjective you're allowed to use is very strong support for inclusion again, correct?
Yes.
All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building, on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile and as a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been it was not dented up and fired. It still had the bullet projectile in the end. It's still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Schulz, well now it's Lieutenant L. Schulz, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
It's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution, from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office, as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
That's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview.
I was.
Did Mr. Twiggs say that he understood that admonition?
He did. Yep. Yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
Your Honor, if I may, Michael Judd on behalf of the media. A request to close a court proceeding isn't a sidebar, and calling it a sidebar doesn't make it one. The court knows the rules at this point. Any attempt to close a hearing requires that the court engage in some sort of hearing about that closure that is open to the public. It can't be done in whisper. That can't be done with the cameras off. There are occasions where a court may find it necessary to put some portion of some hearing behind closed doors. But the conversation about whether or not that happens, of course, has to take place in public. I don't want to belabor any of the points that are made. I think the court recognizes the interests at issue here and what the media's position would likely be on these. I'd like to find common ground. It appears to be a significant piece of common ground here is that everybody seems to believe that the video interview that is at issue here is very important. And that, of course, makes people want to invoke protections, invoke closures. From the media's perspective, from the public's perspective, of course, that pushes the other direction. There may be moments of this preliminary hearing, there may be exhibits that do not present significant pillars of support for the decision that the court will ultimately be called on to make as a gatekeeper and as a magistrate. It seems to me, I haven't seen this video, the public hasn't seen this video, it seems to me that this appears likely to be one of those pillars on which the state intends to base its case and on which the court's ultimate decision will likely rest. That counsels in favor of access, in favor of publication, in favor of allowing the public to see the work that the court is doing and why it's doing it. I recognize Art Chiletta has been invoked. We respect and understand Art Chiletta. Respectfully, Art Chiletta.
I think a closed hearing is appropriate. Setting aside the 1102 issue and objections, there are statements in this video by Mr. Twiggs attributed to Mr. Robinson. Okay? Mr. Robinson said. There are two other exhibits, which I've said before, I'm confident the state will offer, which Mr. Twiggs says in this video, those are statements by Mr. Robinson. Okay? I will acknowledge that separate and apart from 1102, the statements of a party opponent are admissible if relevant. In fact, they're not even hearsay, right? They're excluded from the hearsay rule. But the question is whether statements of Mr. Robinson of the nature that I'm referring to can be published, not considered by the court, but published without violating Mr. Robinson's 14th Amendment due process rights. And it is our view, as we have said in our earlier papers, that the answer is no. Publication, especially in the way this proceeding is being published, would violate Mr. Robinson's due process rights under the 14th Amendment. We previously cited, and the reason why I'm saying this again is not to reiterate something just because if you say it twice, it means something different, but because my colleagues have suggested that maybe my argument earlier was not clear enough. And so I want to make sure it is clear so that the court makes a decision based on the arguments of counsel. The United States Supreme Court said in Estes, E-S-T-E-S versus Texas, 381 U.S. 532, the following. In Rideau versus Louisiana, and that's R-I-D-E-A-U, this court constructed a rule that the televising of a defendant in the act of confessing to a crime was inherently invalid under the Due Process Clause of the 14th Amendment, even without a showing of prejudice or a demonstration of the nexus between the televised confession and the trial. I am not calling the statements of Mr. Robinson confessions, but that is what the state will call them. And so there are portions of this exhibit and the other exhibits that I've referred to which implicate Mr. Robinson's right not to have what the state calls a confession televised. This court has authorized the televising of this proceeding. And there are reporters.
Thank you. All right, I appreciate that guidance, Mr. Novak. So, taking into consideration all the factors, the previous edits, starting at, I believe I said, starting at 6 minutes and 56 seconds, going to 20 minutes and 27 seconds. Does that comport what I previously said?
Yes.
All right. And then the other edit is from 32:55 until 35:48. Does that comport with what I previously said?
Yes.
All right. And then from 35:48 to the remainder 37 can be included. So there is that gap, but that can be included. And part of the reason in responding to the media, and it's an important point, and to the representative for victim representative Erica Kirk, is I recognize the importance of transparency. I also recognize the importance of balancing constitutional rights, and it is a fine line. One of the reasons why for these edits includes under my analysis under 403, going to the last part, needlessly presenting cumulative evidence. And based off the representation of the state that the text messages may be introduced, the court is ruling that this may be revisited in case that doesn't happen. But to throw back the curtain, much of this is the text messages, to be clear. And again, all of this is going to be considered by the court. I'm balancing all these competing rules, the constitutional rights, as well as transparency. And sometimes it is an imperfect balancing act. But I'm trying to act in the interest of justice in making this balancing act and for transparency to actually be transparent. And so that is the ruling of the court as it relates to State's Exhibit 16. Turning to the state.
A little more than halfway down where it begins Wednesday, 11 p.m., will you start reading underneath that?
Yes. So this would have been from Tyler. It says, drop what you're doing, look under your keyboard.
And I apologize, let me stop you there. How do you know that that message would have been from Tyler Robinson?
That's just, so any of the messages in gray would be from Tyler, and messages in blue would be from Lance. It's just the way the iPhone distinguishes the messages. And also Lance in his interview also acknowledges that, who was saying what.
And up at the top, who do we see that this thread is between?
Tyler.
All right, sorry to interrupt you. So read that again, starting from look under the keyboard.
So after that, then Lance responds, he says, what? And then he says, you're joking, right? And then Tyler says, fuck, I tried to delete that.
If we could scroll down to page 2. And if you can continue reading along.
Okay. And Tyler says, I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Shouldn't be long until I can come home, but gotta grab my rifle still. To be honest, I had hoped to keep this secret till I died of old age. I am sorry to involve you. And then Lance replies, you weren't the one who did it, right? And Tyler says, I am, I'm sorry. Lance says, I thought they caught the person. And then Tyler says, no, they grabbed some crazy old dude and interrogated someone in similar clothing. I had planned to grab my rifle from the drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering.
We could scroll down to page 3. Continue reading.
Lance says, why? And Tyler says, why did I do it? And Lance says, yeah. Tyler says, I had enough of his hatred. Some hate can't be negotiated out. If I'm able to grab my rifle unseen, I will have left no evidence. Going to attempt to retrieve it again. Hopefully they have moved on. I haven't seen anything in the news about them finding it. We'll update you shortly, or sorry, we'll update you by midnight. And then Lance says, all right, stay safe. How long have you been planning this?
Scroll down a little bit, please, Kimberly.
And Tyler replies, a bit over a week, I believe. I can get close to it, but there is a squad car parked right by it. I think they already swept that spot, but I don't want to chance it.
We can scroll down to page 4 and continue reading about halfway down. I'll stop you about halfway down.
This is while they were spot, but I don't want to chance it while they were parked there. If they had found it, I imagine there would be more commotion. Again, I'm sorry for roping you into all of this. You shouldn't have to worry about this. And Lance replies, does anyone else know? Tyler says, not to my knowledge.
All right, I'll stop you there.
And then Lance says, why did you leave it behind?
Oh, sorry, Kimberly, if you could scroll down.
Originally. Also, does it have a serial number?
We could scroll to page 7. And I'll continue reading. I'll stop you on this page in a little bit.
Okay. So Tyler continues, IDEK, if it had a serial number, but it wouldn't trace to me, I worry about prints. I had to leave it in a bush where I changed outfits, didn't have the ability or time to bring it with.
And stop there, please. And then if we could go to the next page, page 8. And if you could start at the top.
Okay, so Lance says, was your change of clothes there, or was that also gone? Or did you bring those with you originally? Anyway, you could replace the gun, or would he notice? And then Tyler says, only thing I left was the rifle wrapped in a towel. I'll bet that canine sniffed it out. Little snitching bastard. Replace it unlikely. I don't fully know what the gun was because it was old as shit, and Gramps did some modifying. There was a 4-digit serial on it. God only knows who it's registered to. Hopefully some dead guy who gave it to Grandpa. And he continues, remember how I was engraving bullets? The fucking messages are mostly a big meme. If I see notices bulge UWU on Fox News, I might have a stroke.
And then continue. I'll stop you in a moment.
He says, all right, I'm going to have to leave it. That really fucking sucks.
Let me stop you there. And then if we could go on to the next page, page 9. And do you see the first blue message we see on page 9? Can you start there?
Yes. So Lance says, do you need it for hunting? And Tyler says, no, my dad wanted to use a high caliber for the rifle hunt. Judging from today, I say Gramps' gun does just fine. IDK. I think that was a 2K scope. Lance says, geez. And then Tyler says, OMW home 3.5 hours. Lance says, drive safe. And then Tyler says, delete this exchange.
And I'll stop you right there. And then, sorry, we're on page 9. If we can scroll to page 15. And then the second grade message on page 15, if you could start there.
Okay. So this is Tyler. I'm going to turn myself in willingly. One of my neighbors here is a deputy for the sheriff. We hope to keep things sort of quiet here.
And then I'll stop you there.
Okay.
And we can,
The media may pick this up as well.
Agent Davis, if I can direct you to the very last message on that page, starting with if any, if you could read that out loud.
Okay. This is Tyler. He says, if any police ask you questions, sorry, let me start over. If any police ask you questions, ask for a lawyer and stay silent. My lawyer should be Doug Terry. I'll see if he can reach out to you and make sure the police follow.
Okay, thank you. That's all I need from that exhibit. And then finally, Agent Davis, you testified before that you flew down to Washington County Sheriff's Office and observed Tyler Robinson there, correct?
Correct. Yeah.
You got his name there.
Yes.
You stated that you transported or assisted transporting him up to Utah County Jail.
Yes.
And that you were the booking officer.
That's correct.
Do you recognize Tyler Robinson here in the courtroom today?
Yes, I do.
If you could point him out and briefly describe something that he's wearing.
He's an individual seated at the defendant's table in the center chair with a gray suit coat and a green tie.
Your Honor, if record could reflect identification of the defendant.
Counsel?
No, Judge.
All right. I'll note for the purposes of this hearing only that Agent Davis has identified Mr. Robinson in court. Thank you.
And Judge, if I can just have a moment.
You may.
Ready to pass the witness, thank you. And I don't know if now would be a good time for lunch.
All right. We'll go ahead and break right now for lunch for 1 hour, 1 hour and 5 minutes. Let's come back at 1:30. We'll resume. We'll pick up with defense for cross-examination if they choose for Agent Davis. Does either party need the benefit of the record before we go on our lunch break?
Not the state.
No cross-examination for Agent Davis, so I don't want him to wait here if he has other things to do.
Thank you.
Thank you, Mr. Novak.
Thank you.
No cross-examination. May this witness be excused.
Yes.
All right, Agent Davis, you may
Thank you.
step down,
Thank you.
and then we'll resume with the state on their next.
Area of the crime scene, collect the latent prints and the shoe impressions that you've talked about.
Yes, they did.
And this is a good point to read a stipulation into the record.
All right.
The language of this has been agreed upon by the parties. The parties stipulate that investigators at the crime scene observed latent fingerprints and a palm print on a glass window near the area where the individual landed when the individual jumped from the rooftop of the Low-C Center at UVU. SBI fingerprint examiner Elisa Farmer examined images of these latent fingerprints and the palm print and determined that only 3 of the latent prints, 11B, 11C, and 11D, were of comparable or of poor comparable value. She excluded Tyler Robinson as the source of any of these 3 latent prints. Ms. Farmer reviewed other prints on the window and found that they did not have adequate value for comparison. Subsequent examinations of these 3 latent or actual latent prints by the FBI were inconclusive. That area that was described in that stipulation, is that the area in the glass window that you're talking about?
Yes, that is.
That's on the northeast corner of the Low-C Center.
Yes.
And that's the area where we see in a video an individual drop from the roof.
I mean, we certainly can. Yes, would you like to put on the record what were published and what were not published?
No, that's okay, Judge.
Okay, we're good. And then, all right.
Can I have just a moment?
Yes.
Your Honor, the state rests its case in chief.
Thank you. Turning to defense. Approach the bench, please. I'm not ruling that that cannot happen, but for today, we need to focus on this to getting this defense witness on the stand and off the stand. And so please, if I do not remember, the parties can remind me and we can revisit this tomorrow. So again, I'm not saying yes, I'm not saying no, I'm simply saying we need to get to this witness, and I'm happy to readdress this tomorrow. Okay? All right. Mr. Burt. All right. Samantha Carner is being requested. If you can go ahead and retrieve her, bring her into the courtroom.
Someone is doing that.
Is somebody grabbing her?
Yes.
Okay, thank you, Mr. Burt. I just couldn't tell and wanted to make sure. All right, Ms. Carter, if you wouldn't mind coming forward, right by our bailiff to be sworn in.
Please raise your hand. Do you solemnly swear that the testimony you're about to give now before the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. You can sit.
All right, thank you, ma'am. If you wouldn't mind coming forward, having a seat at the witness stand. To your left is a water bottle if you choose. It looks like you brought your own as well. And after you're situated, if you wouldn't mind pulling that microphone toward you, just to ensure that your testimony is picked up on the record. Mr. Burt, your witness.
Thank you. Good afternoon. Could you tell us your name, please?
Yes, my name is Samantha Carner.
And Ms. Carner, what do you do for a living?
I am a firearm and toolmark examiner.
And where are you stationed?
I currently work at the Forensic Science Laboratory in Washington for the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And how long have you been employed at that location?
A little over 6 years.
What generally do you do there, which are also documented in this file in the way of comparison photographs?
All right. As it relates to the objection is overruled. I find that this is relevant as it relates to State's Exhibit 30, which was admitted, as well as State's Exhibit 32, which is admitted, and the state is able to do cross-examination on this witness as it relates to this report. And so it is admitted and may be published on all levels in the courtroom and through the media.
Thank you. Ms. Carner, one of the items you were asked to look at was, as described in your report, 1 bullet jacket fragment and 4 lead fragments, correct?
Yes.
Were you informed at some point that there was a discrepancy between what you were examining and what had been documented by the medical examiner in terms of the number of bullet fragments?
I was, yes.
Were you asked to see if maybe the ATF had lost certain portions of the evidence?
No, I was not.
Right. Do you think, and was it your understanding that there were originally 7 bullet fragments, but you ended up with 4?
I was alerted that there was potentially 7 fragments from the medical examiner in a photo just a few months ago.
Okay. You're clear, though, that when you got the evidence, it was in a sealed condition, correct?
It was, yes.
And when you you concluded here, did you not, that the Exhibit 6A bullet jacket fragment could not be identified or excluded as having been fired from the Exhibit 1A based on an agreement of all discernible class characteristics and neither sufficient agreement nor sufficient disagreement of individual characteristics? The result of the comparison was inconclusive.
Yes.
That was your ultimate conclusion, right?
Yes.
And on the next page, if you could go to 2 pages in, you have an appendix, do you not, where you explain what inconclusive means? Next page. One more. There we go. I want to ask you, because I'm unclear on what inconclusive means. You say reasons for an inconclusive or include the presence of microscopic similarity that is insufficient to form the conclusion of source identification a lack of any observed microscopic similarity or a microscopic similarity that is insufficient to form the conclusion of source exclusion. Could you specify which of those possibilities exists in this case? Was this a case where you had microscopic dissimilarity, but in your opinion, it was insufficient to form a conclusion of source exclusion?
No, my conclusion is inconclusive, just as it says in the appendix. There is a lack of sufficient agreement and sufficient disagreement, so I'm unable to say one way or another.
Okay, but I guess my question is, were there points of dissimilarity between the question and the known bullets?
Again, there was sufficient agreement and there was not sufficient agreement or sufficient disagreement. So yes, there was times that I saw agreement in the striations and the landing group impressions, also seeing disagreement, but there was also a lot of lack of microscopic marks of value to see it all. So because of this lack of quality and quantity of marks to be able to see, it never reached the threshold of sufficient agreement nor sufficient disagreement. So an identification or exclusion could not be rendered.
Okay, I think you and I met a forensic science discipline that has an error rate higher than 5% is not reliable.
I don't know that I have opinion to that because I think it's a little on the broad side. I don't know what you would consider high as far as a percentage.
Well, I'm referring to the statement at page 151 where they say methods with a high false positive rate are scientifically unreliable for making important judgments in court about the source of a sample. To be considered reliable, the false positive rate should certainly be less than 5%, and it may be appropriate that it be considerably lower depending on the intended application.
I would agree with that statement.
You would agree with that. And you also lastly reference your knowledge of the study by the AFTE of that proficiency, the one proficiency test which you have taken on bullet comparisons, correct?
Correct.
And the error rate in that particular study, proficiency test, was 20.4%, correct?
Correct.
For item 2, 18.2% for item 3, and 18.9% for item 5.
I believe those were the results. However, I don't agree that proficiency tests are what are used for validation studies to show foundational validity.
So if the error rates are high, then they shouldn't be relied upon to show invalidity, but they should be relied upon to establish that your experience means that your science is valid? Is that what you're saying?
Foundational studies are looking at, just as PCAST said, those black box studies, different test design, all of which firearm and toolmark community has conducted. We've looked at cartridge cases, bullet, pristine samples, damaged samples, and different firearms. Proficiency test is looking at the accuracy of an examiner's results, not foundational validity.
But you would agree that an error rate of 20% is unacceptable, would establish unreliability, correct?
I would agree that those results need to be looked at to see where that error was coming from.
Right. Okay, thank you.
Thank you. Anything further for this witness? Yes. And Mr. McBride, I'm going to limit you because your objection to going outside and going to 702, you opened the door, but I've got to close that door to some point. So I will give you a limited number of questions. We need to come to a close.
I understand that. Your science has been accepted by courts across the country, correct?
Correct, yes.
It's routinely admitted in courts across the country, correct?
That is correct, yes.
Your science has been peer-reviewed and viewed favorably by numerous publications and studies across the country and across the world, correct?
Correct, yes.
No more questions.
All right. Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, The court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
Inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other parties wish to be heard as it relates to Mr.
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Ms. Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report, and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burton. Before Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Ms. Oliver, could you bring that mic a little bit closer so I want to make sure your voice is projected? Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right, and they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against a possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30, page 8? Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained, and then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1?
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number could be a lot higher. It could be quintillion, octillion. We chose 1 trillion because it has meaning, I think, to people that can understand what 1 trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap, and they say, the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is, once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there is support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolts of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And
Again, not because he's a suspect, but because he's associated with that premise.
Correct, and there would have been a likelihood ratio statistic calculated and to go along with that.
Okay. Could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There is support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you by those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number, or exhibit number 30. If we can pull that up just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6?
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
Free sample is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together, so I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors. Correct?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing. It has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called the random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right, so part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused.
Yes.
All right. Thank you, ma'am. You may step down. Anything further from defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1 so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
Is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right, in regards to...
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.